Hello, namaskaram. My name is Pooja Dwivedi. Welcome to my class, The Daily Current Affairs. What can you expect in these classes? First, you will get to know all the important news of the last 24 hours. Second, you will understand how UPSC Prelims work. Third, you will start developing the skill for solving UPSC preliminary questions if you attend these classes on a daily basis. And fourth, immense knowledge and conceptual clarity. By the end of this class, you are expected to know about all these many things. These many things we are going to cover. This is going to be a class which is going to be jam-packed with many concepts and knowledge. Do not try to make notes because I provide the notes in the form of this PDF on my Telegram channel. That is by the name of Pooja Dwivedi UPSC. Other than this, if you have any queries regarding this examination, you can also talk to me on my Instagram. Now, from 11th of August, we are launching our P2I batches. These will be available in Hindi, English and English. I will be taking up classes in these. Also, it's a one-stop solution for all the students who are going to, be a part of this particular batch. Why? Because we are going to provide you everything. From prelims test series to mains test series, daily answer writing practice, current affairs module, everything will be provided to you at rupees 70,000. But it's not at rupees 70,000, but because if you use the code PD Live, it will be made available to you at 29,999 only. 11th of August is the date. It will be a morning batch. Do not worry about missing classes because these will be live classes. You will be able to interact with the teachers. Do not worry about that. We will also provide you recorded versions once if you miss them. Okay, moving on. Consider the following statements. Students have answered this question correctly. I will take up the names of those students who have answered this question correctly by the end of this segment. But let's first solve it together. The Constitution empowers the President to specify a scheduled tribe in a state or union territory after consultation with the governor. The Constitution does not specify the criteria to determine SC status. The ST list is not a nationwide list. So what do we have to see? How many statements given above is or are correct? See, recently, scheduled tribes have been in the news for a long period of time. Since a very long period of time, we are reading the news about scheduled tribes. So it is important for us to know about them. The Constitution actually has defined scheduled tribes, as in, it has not provided a proper close-ended definition, but a really open-ended one. According to Article 366, Clause 25, it has empowered the President by the help of Article 342, Clause 1, to define any tribe as a scheduled tribe. And that has to happen with the consultation of the governor of the concerned state or the union territory. Because the scheduled tribe list is not a unified list, is not a uniform list, not a nationwide list. It can differ from one state to another and one union territory to another. So first statement is definitely correct and third is also correct. Also, the Constitution does not have any sort of criteria. It's not written in the Constitution that these are the 4 to 5 criteria. If a tribe is fulfilling these criteria, you can declare them as a scheduled tribe. It's not like that. There is a set convention, a procedure that has been followed, a commonality that has been observed between different tribes. And on the basis of that only, we were able to chalk out the criteria. It's not mentioned in the Constitution. Do not get confused. So all the three statements on that very fact is correct. So the correct answer will be all three. The centre has recently brought 4 bills related to Jammu and Kashmir in the parliament to ensure that certain tribes are defined as scheduled tribes, and the Constitution Scheduled Tribe Order Bill 2023 as well as the Reservation Bill of 2023 is amongst them. Now, scheduled tribes in India are defined so as in empowers the President to define so by the help of Article 342. 366 Clause 25 says that such tribes or tribal communities or parts of a group within such tribes or tribal communities are deemed under Article 342. Now, why there is a mention of parts of group or a tribe within a tribe, because supposedly, let's take the example of Kuki tribes. The Kuki tribe is not a monolith tribe. That is, a Kuki tribe can consist of many other tribes in itself. That is why tribe within a tribe is a concept. And accordingly, the president, in consultation with the governor of the state or the union territory, will determine who is a scheduled tribe according to Article 342 Clause 1. There is another Article 342 Clause 2 which says that the Parliament may by law include in or exclude from the list of scheduled tribe specified in a notification which is issued under Clause 1 any tribe or tribal community or parts of a group. So Parliament has also been empowered as in to include or exclude any tribe from the list. It is not the state legislature but the Parliament. So you have to remember this, because the UPSC examination can also ask you, it's the state legislature, because everything starts from the state. As I have already told you that the list differs from state to state. Okay, moving on. The ST list is not a nationwide list. Remember that. It differs from state to state and the union territory to union territory. Also, the constitution doesn't give us any specified criteria, although by the convention that we have followed, primitive traits should be there. That is, they are following very old sorts of agricultural techniques. Primitive in nature, not modern technology. Secondly, they have geographical isolation. Because of that, backwardness has occurred or shy of contact, and a distinct culture. Culture should be preserved of each and every tribe if they have to, for diversity of India. India is a diverse country. The country's first order related to scheduled tribes, it was the Constitution Scheduled Tribes Order of 1950, which was given by the then President of India, Dr. Rajendra Prasad ji, and it contained state-wise list of tribes, and it was followed by 16 similar orders until 2016. Now next question. Consider the following statements. Matsya 6000 will take 3 Indians or humans to a depth of about 6,000 meters into the ocean. Matsya 600 is made up of carbon fiber alloy and the submersible's hull will be made perfectly spherical. So what do we have to see? How many statements given above is or are correct? The Deep Ocean Mission, which has an allocation of 4,077 crore rupees. Under this only we have the Samudrayan or Samudrayan Matsya 6000. It is a submersible that has the aims of looking into the resources that we can find in the deep ocean. Deep mining can be done or not of polymetallic nodules, and also what is the condition of the biodiversity. So this submersible will take 3 humans. It's a submersible which has a capacity of taking 3 humans up to a depth of 6,000 meters, and it is made up of titanium alloy and not carbon fiber because of the depth that it is going in. We have all seen what has happened to one more submersible that went to explore Titanic. So we have to ensure that it has the hull should be perfectly spherical. Even a small deviation from the perfectly spherical shape, it can lead to crushing of this submersible because it won't be able to sustain the immense pressure that the water will create at that depth. That is why first statement is correct, second statement is incorrect because it should be titanium, and third statement is correct. So what do we have to see? How many are correct? 2 only will be the correct answer. The country has developed the Matsya 6000. Who has developed it? It has been designed and manufactured by National Institute of Ocean Technology. Okay, remember that. National Institute of Ocean Technology, and it is a part of the Deep Ocean Mission only. Okay, it has so many important features. We will discuss that, but before that, remember, it has been both designed and manufactured by the National Institute of Ocean Technology only. It can carry 3 humans for a period of 12 hours. In case of emergencies, it can go on further as well, up to a depth of 6,000 meters, and it has the aim of deep sea mining as well. It will go 1,500 kilometers away from the Kanyakumari, of the coast of Kanyakumari, Carbon fiber is strong, but it is not fracture resistant because at these kind of depth, 6,000 meters, we need to ensure that we have a better material, and titanium is the most preferred one. It also consists of a flotation device that would rise to the top and determine the physical location of the submersible so that it doesn't get lost. The titanium, this particular titanium is stronger than steel but many times lighter. Depending on the depth, at which depth does a submersible have to go, on that choice and cost efficiency, we can decide we want to use steel, carbon fiber or titanium. It's also crucial that the submersible's hull be made perfectly spherical. A small deviation can lead to the crushing of that particular submersible. Consider the following statements. Odisha is a major contributor in the number of anthrax cases. The H1N1 flu has never been declared as a pandemic. So what do we have to see? Which of the statements given above is or are correct? H1N1 influenza is nothing but swine flu. It made headlines in 2009 and it was also declared as a pandemic when the outreach spanned across many countries. So that is one of the criteria for any disease to be declared as a pandemic. So second is definitely correct. First, Odisha is a major contributor in the number of anthrax cases. That is also correct. Anthrax is caused by a bacteria. It commonly occurs in the soil and it usually affects the wildlife, cows. And if a person comes in contact with that animal, they can have this disease, anthrax. H1N1 influenza is basically a cocktail of bird flu and human influenza, which is stored in a pig. The pigs harbor it. That is why it is known as swine flu. And it usually infects pigs, but if it can infect humans, then it's a zoonotic disease. That means it can jump from one species to another, from the species of animals to us. And if we become sick, we can also infect other humans. So both these statements are actually correct. So both 1 and 2 are correct. Now let's move forward. It is said, it has been reported that India is developing vaccines for anthrax as well as H1N1 influenza. We are so motivated by the way we have handled the COVID-19 with the help of vaccination that more occurrences of waves did not occur. That has been one of the biggest reasons that we were vaccinated enough. So, swine flu, it is known as H1N1. It is caused by H1N1 virus. And it's a relatively new strain of influenza virus. New strain means it was never seen before in humans. And it's a cocktail of bird flu and human flu, which is harbored by pigs. Pigs store it. And then if a person can get infected from pigs, it's generally not from eating, a properly uncooked pork. It doesn't happen like that, but close contact. If you eat it, it won't happen. And it can get from one human to another human by inhaling the viral particles, and then high fever, coughing, sneezing, breathing difficulties will occur. That is why we must also wear mask. For that very reason. Symptoms are just exactly like regular flu, but we have to understand, we have to get diagnosed with it in order to ensure that other people are not infected by it. Swine flu was declared as a pandemic. It was first discovered after that, it was also, it was said that it doesn't occur in the category of pandemic anymore by 2010. Swine flu is caused by a strain of influenza virus. Now it is just like a common flu. It is circulating still. Okay, it usually only infects pigs. Usually only. And it can go from pigs to humans. That means it has developed the ability to jump species. Anthrax is an infectious disease which is very serious. It's caused by gram-positive rod-shaped bacteria. This bacteria is Bacillus anthracis, this bacteria. And it has caused plagues in Europe as well. Like black skin lesions occur if a person gets infected by it. It usually occurs naturally in soil, commonly affects domestic and wild animals, and if a person gets infected through that, they can also get infected by this disease. People can get sick with anthrax if they come in contact with infected animals or even contaminated animal products. Alright, moving on. Odisha has been the major contributor of anthrax in the Indian national disease burden. All right, moving on. With respect to the drone laws in India, consider the following statements. Drone laws are nothing but the laws which are related to drones or unmanned aerial vehicles. There are 5 categories of drone or unmanned aerial vehicles in India. It is not required to get a license from DGCA separately. Keywords we have to remember: not required to get a license separately. Separately is the keyword over here. After getting trained from a DGCA approved drone training institute. And nearly 90% of India's airspace has been opened up as a green zone for drones flying up to 400 feet. So how many of the statements given above is or are correct? There are 5 categories of drones. That is very correct. And recently it has been reported in the parliament that up to 90%, nearly 90% of the India's airspace has been opened up for those drones which will fly up to 400 feet. Recently, when the rules were changed for it, it was mentioned that if you get trained from a DGCA institute, then you do not need to apply for a separate license to fly certain routes. Okay, and there are 5 categories. I've already told you that. All the 3 statements are correct. All 3 will be the correct answer. I have already told you about this. And as on 25th July of this year, there are 63 remote pilot training organizations which have been authorized by the DGCA for imparting drone training across the country. Nano drones are less than or equal to 250 grams. Micro ones are greater than 250 grams, but they are less than or equal to 2 kg. Remember that because it can also be given in pairs. Prelims can ask you a pair question. You have to match the weightage with the category they fall in. Then small, greater than 2 kg, less than, equal to 25 kg. Then medium, greater than 25 kg, less than or equal to 150 kg. Then we have larger. These are greater than 150 kg. To fly a micro drone, we need some kind of training, especially for commercial purposes. It is advisable that one gets trained from a DGCA approved remote pilot institute so that permits are not required later on. Alright. Next, the Rex versus Sussex Justices case is related to appointment of judges, retirement of judges, recusal of judges, removal of judges. I hope you will be able to answer this question. A very tricky question can be formulated from here. If you do not know about certain important origins, you may be faced with such difficulties. It is related to recusal of judges. What is recusal? Recusal is nothing but when a judge says that I may not be able to participate in the following case. Why? Because I may have a conflict of interest. And there are no codified rules in India that dictates that a judge should recuse from certain judgments or certain cases. We will find about that only. So the Rex versus Sussex Justices case is related to recusal of judges. Why have I asked you this question? You ask. Supreme Court Judge Justice P.K. Mishra has withdrawn from hearing a petition for bail which was filed by former JNU student leader Umar Khalid. And this is in relevance with the unlawful activities case. It is related to the February 2020 Delhi riots. What is his connection with them, with the riots? So, whenever a judge withdraws from these sort of cases, it is known as recusal. And it means that there is a potential conflict of interest. How can a potential conflict of interest occur? When there is a judgment or a case in which a company is involved, and in that company, the judge may have holding share in that company, having a prior or personal association with a party. Why is it done? Why recusal is resorted to? It has to look like that judgment is given in a neutral and unbiased manner. If I am personally related to some person and I am a judge in a particular case related to that person, whatever may be the decision, it may look like that I am biased towards that person. If it's a positive, then also it can go in that manner. If it's a negative, it may look compensatory. It may look I was trying to compensate my personal relationship by giving an untoward judgment. So judgment should not only happen, any judge should not only pronounce a judgment, but it should also seem like that the judge is doing justice. Justice provided is okay, but it should also seem like the justice is being provided. So this is the basic principle on which recusal happens. Okay, so when an appeal is filed in the Supreme Court against a High Court judgment delivered by the concerned judge before his elevation, so then also it would look like that this judge gave this particular judgment in the High Court as well. Now he is elevated to the Supreme Court, he or she. Then they can also do the same for this particular judgment as well. So this becomes conflict of interest. It gets its root from the cardinal principle of due process of law. That means every constitutional procedure as in is being followed. Supposedly, the accused is being given enough space to present their defense in a particular manner. It should seem very justice or justifiable in manner. So it means nemo judex in sua causa. That means no person shall be a judge in his own case. Justice must not only be done, but must also be seen to be done. It has been propounded in the 1924 in Rex versus Sussex Justices by the then Lord Chief Justice of England. That means it also has a root in the Constitution as in, it's not provided that recusal of judges subheading and then after that, not like that. That means a judge should pronounce any judgment without fear or favor, affection or ill will. This is given under the 3rd schedule of the Indian Constitution. Another is the restatement of the values of judicial life by the Supreme Court, in which it has forbidden a judge from deciding a case involving any entity in which the judge is holding pecuniary interest. If a judge has an interest in that particular case and that is personal in manner, then it has been dictated by the restatement of the values of judicial life. Unless the concerned parties clarify that they have no objection, this can also be done. Then recusal can also happen in two manners. First, automatic recusal, where a judge himself withdraws from the case. I do not want to be a part of it. Why? Because I may have pecuniary interest. A personal bias can occur. Also, when a party raises a plea for recusal, highlighting the possibility of bias. If I am the accused and I know this judge may cause problems for me because he has or she has pecuniary interest in my case, my matter, I can also have a plea for it. And it is solely on the conscience and discretion of the judge. It is not based like if I have highlighted that then the judge has to leave this case. It's not like that. It has the judge, if the judge has a conscience, clean conscience, and the judge knows that maybe I am unbiased. I know I am unbiased. I have integrity. But if the world will question my integrity based on the interest that I have, the personal interest that I have, I may not want to do it. So it's on my discretion. No party can compel a judge that you have to leave this case. It's not like that. Okay. If a judge recuses themselves, then the case will be listed, shall be listed for the Chief Justice so that they can allot it to some other judge. India has no codified rules for governing it. Okay. Consider the following statement. Statement 1 says the UGC plays that standard setting role even in the case of appointments in the case of universities and colleges. Second statement says, although education comes under the concurrent list, but the union list gives the center substantial authority over the higher education. So we have to choose the correct answer from these codes. See, we have to understand that education is in the concurrent list. Means what? Both the state and the union government can make laws and rules regarding that. But we all know what happens with such subjects. The laws of the union government prevails because that has been also one of the constitutional provisions. See, although education comes under the concurrent list, but entry 66 of the union list gives the center substantial authority over the higher education. And the UGC for that very matter has such powers for appointment in universities and colleges. So, both the statements are correct and statement 2 correctly explains the statement 1 for that very matter. Option B will be correct. Now, what is happening in West Bengal has been happening since a long period of time. West Bengal CM does not like any of the governors. Of course, she's in complete conflict with the central government. And this hasn't happened for the very first time since ages. West Bengal, even if we talk about in erstwhile medieval times, it was very hard for any central authority to have a connection with Bengal, to have an authority over Bengal. So this has a root in that. Mamata Banerjee has seen that since a very long period of time. She is not ever happy with the central government. And it's okay because our constitution provides for this mismatch. It's not at all something that we should look politically but constitutionally. So let's know what is the matter. Mamata Banerjee is in a face-off again with the governor, with the Raj Bhavan, because she is not happy that the governor is the chancellor of universities, state universities. She has brought a bill last year that this bill will make me, the CM, the chancellor of the state university. Like other states also have this provision. But the irony is, in order to pass that bill, it will be a huge role of the governor. Now you're in conflict with a party who you want to replace with their consent. This is what is happening. And since a long period of time, we are watching that even in ancient and medieval, specifically medieval times, it was very hard for any central authority to tame Bengal. And this is happening with West Bengal in a similar fashion. So the face-off is intensifying, and she has urged the Raj Bhavan to ensure that this bill gets passed. This was introduced last year, West Bengal University Laws Bill, that CM should be the chancellor and not the governor. As the chancellor, the governor has the power or responsibility to appoint the vice chancellors in the state government run university. They also have the power to annul decisions of the decision-making bodies of universities such as the executive council, to make appointments to these bodies, and they also enjoy the powers to preside over the convocation of universities. But we also have to see the UGC norms. See, first, education comes under the concurrent list, but entry 66 says of the union list that coordination and determination of standards in institutions for higher education or research and scientific and technical institutions. This gives the center substantial authority over the higher education, and UGC because of that plays the standard setting body. As very importantly, governor is a part of that standard setting body, and according to this regulation of 2018, it has been also mentioned like visitor or chancellor, which is mostly the governor in the state. It can also not be in many other cases. Okay, in the state shall appoint the VC out of the panel of the names recommended by the search cum selection committee. So this is not anything but a tussle for power in state-run universities. What kind of subjects, what kind of interest should be made available in these state universities will be impacted, and many other states such as Gujarat, they have a different provision that can also help West Bengal to carve its own chancellorship for the CM. With respect to the voice vote, consider the following statements. It is a practice which is unique to India and was developed after independence, and it is a quick and highly accurate tool used to decide bills. Which of the statements given above is or are correct? Voice vote, that means voting by voice. And it has proved to be quick because what happens? The speaker puts a bill into question, and by the numbers of yes or no, the speaker gets to decide if the bill gets passed or not. And in this similar fashion, it is known as very efficient. It is not unique to India, and it was also in practice before we got independence. So first statement is incorrect. It's not unique to India, and it was there before independence as well. Although it is quick, but it is highly inaccurate. Why? It's not highly accurate. Why it's highly inaccurate? Because it is decided by the loudness of the voice a group makes. Which group is louder decides the bill has passed or not. So this is not accurate. This is highly inaccurate. So first and second both are correct. Sorry, we had to select the correct ones, right? So both these are incorrect. Neither one nor two will be the correct answer. So let's move on and talk about these bills which have been passed in Rajya Sabha by voice vote. The Constitution Order Bill 2023, Anusandhan National Research Foundation Bill 2023, Digital Personal Data Protection Bill 2023, and the Coastal Aquaculture Authority Bill 2023. Voice vote really should be a proper discussion. But let's see. A voice vote involves the speaker putting a question. I've already told you the procedure, right? An advantage is quick, disadvantage, it's highly inaccurate. The concept of this has been borrowed from the Parliament of the United Kingdom, and it was already in use in the legislature during British times. Consider the following statements. The earliest epigraphic record that mentions Kerala is Emperor Asoka's Rock Edict II. The origin of the term Keralam could possibly, this is a theory, that is why could possibly has been used, from the root sh, which means, or cher, that means to join. Okay. Then a constitutional amendment becomes necessary to change the name of a state. So how many statements given above is or are not correct? Recently, the Kerala government has said we want our state to be known as Keralam. As Keralam, it is called so in Malayalam. And Malayalam, on the basis of languages only, many states have been carved out. So why is it not Keralam and Kerala? This is the question of the government of Kerala. And it is important that the Ministry of Home Affairs, when they take the matters, when it passes from the state government to the Ministry of Home Affairs, and it needs a constitutional amendment for such things to happen. And this is dictated under Article 3. The Parliament has been made the authority over such matters according to Article 3. So yes, a constitutional amendment becomes necessary whenever the change of names have to occur of a state. So third statement is correct. The origin of the term Keralam, it comes from the word chera, that means to join. It is all a theory, but still this is a strong theory. Second is also correct. And the earliest epigraphic record that mentions Kerala is Emperor Asoka's Rock Edict II. Okay, all three are actually correct. Not correct we had to select, right? None will be the correct answer. None are not correct. All are correct. Moving on. The Kerala Assembly has passed a resolution urging the state to rename the state as Keralam in the constitution and all official records. Now what will happen? The arguments which have been presented, the name of our state in Malayalam is Keralam, and states were formed on the basis of language on November 1st, 1956. That is also known as Kerala's formation day. And the first schedule of the constitution mentions the name of the state as Kerala. Why? Article 3 of the constitution has been given to look at this particular matter only. The formation of new states are dictated by Article 3. Whenever it happens, the Parliament will be authoritative in these matters. Any changes or modifications to existing state names, even boundaries or areas, all right? And a constitution amendment becomes necessary to give effect to such matters. The proposal first comes with the state government. It passes to the Ministry of Home Affairs. Then the Ministry of Home Affairs looks for no objection certificate from many agencies. Ministry of Railways should not have any objection. Intelligence Bureau should not have any objection. Department of Posts, Survey of India and Registrar General of India, because they also will have to change the names in their different documents. Logistical cost will also be a lot because they have to change the names in the railway stations, the documents, the papers, and it will also be costly. So that is why. Then after that, resolution which is brought in the form of a bill is passed by the Parliament and then becomes a law. Okay, moving on. The earliest epigraphic record mentions Kerala in Emperor Asoka's Rock Edict II of 257 BC. The inscription refers to the local ruler as Kerala Putra or sons of Kerala. Also, son of Chera refers to the Chera dynasty. Keralam means Cheram. It comes from the root word Cheram. Okay, this is the region, the Chera kingdom. Alright. Now, Dr. Herman Gundert, when he published the first Malayalam English dictionary, he mentions here as a theory that Keram is the Canaries or Kannada form of Cheram, and Keralam has got its name from Cheram. The region Cheram is between Gokarna and Kanyakumari. Here, like this. And yes, it coincides with the current state. Root word is Cher, which means to join, and Cheralam, here Alam means region or land. Okay. Now, next question, the 13th amendment, which has been in the news a lot. It is often seen in the news as a point of concern between which two countries? The correct answer will be India and Sri Lanka. India wants the Sri Lankan government to implement the 13th Amendment in letter and spirit because we have a concern for the Tamilians who are living there. And why are we concerned? Because Tamilians, first of all, they come from Tamil Nadu, which is an integral part of India. We have to take care of them, even if they're residing in different countries. Another thing is that if there is any sort of dispute in our neighboring countries, we will be at the receiving end of the refugees and it will put a lot of pressure on our resources. That is why it is important for India to ensure that other countries, which are neighboring countries, have democracy. Alright, moving on. Sri Lankan President Ranil Wickremesinghe on August 9th reiterated his offer to the Tamils of implementing the 13th Amendment without police powers because Tamilians there want police powers as well. Let's talk about it. See, the 13th Amendment actually has a root in the Indo-Sri Lanka Accord of 1987, in which it is mandatory that the powers which are very centralized in nature in the hands of Sri Lankan government, it should be decentralized, it should be provided to the provinces of Sri Lanka so that when there is decentralization, there will not be, fear of any sort of other pressures such as you can say disturbance in their socio-culture. So, when there is a decentralization of power, there is a sense of security among these provinces that they have the right to follow their own culture, to follow their own administration, and this has an accord. This has a root in the accord, Indo-Sri Lankan Accord of 1987, and this was signed between Prime Minister Rajiv Gandhi back then and President J.R. Jayawardene. And according to the 1978 Constitution of Sri Lanka, Sri Lanka had a unitary government with powers in the hands of the centre. And this centralization caused a lot of disruption and war between the Liberation Tigers of Tamil Eelam and Sri Lankan government. Why? Because most of the powers were going to the northern and eastern region of Sri Lanka. But other regions which were at the receiving end of these two regions, they were not happy with it. So that is why this particular war took place. And the 1987 Accord amends the constitution to transfer some powers from the central government to the provincial governments, and it allows the devolution of powers to provinces. Other things are also there, such as Tamil and English being adopted as official languages with Sinhala, lifting of emergency on the eastern and northern province by August 15, 1987 back then, surrender of arms by militant groups, and general amnesty to the political and other prisoners held in custody under the Prevention of Terrorism Act and the emergency laws. That means general amnesty means pardoning. The Government of India, according to this accord, will underwrite and guarantee the resolution, cooperate in the implementation of these proposals, and the Indian Prime Minister did urge the Sri Lankan government, please implement it as soon as possible, and the Tamilians have also urged the Indian government to make sure that Indian government is cooperative enough. Next, with respect to Asiatic lions, consider the following statements. The Asiatic lion faces threat of genetic inbreeding. Gir National Park and Wildlife Sanctuary is the only abode of Asiatic lions. They are slightly smaller than African lions. They are listed as endangered on the IUCN Red List. So let's see how many statements given above is or are correct. 1 only, 2 only, 3 only, all 4. So let's see that. See, Asiatic lions, because we have a limited population of them, that is why suffer from genetic inbreeding. That means they breed among their own family members, as nature has given them that only option. What nature? We as humans have given them that option. Whenever there is genetic inbreeding, what happens? Different sorts of diseases occur and their genetic pool gets diminished. When the genetic pool gets diminished, they may have a lesser chance of survival. So yes, the Asiatic lion faces threat of genetic inbreeding. Okay, then Gir National Park and Wildlife Sanctuary is the only, actually, the intellectual tricks that have been long held, that when there is a word such as only or all, that statement is definitely correct. In this particular matter, that particular statement is incorrect. But in this case, this is correct. Because yes, second statement is very correct. And they are slightly smaller than African lions, their size. They are also listed as endangered in the IUCN Red List. So we can say that first, second, third, fourth, all are correct. All 4 will be the correct answer. Today is the World Lion Day. The population of them is decreasing in the entire world. except in Africa. But we have seen that back in 2013, World Lion Day was established in an attempt to preserve the lions and also ensure that the world knows about their importance, how important they are to check the ecosystem, keep the ecosystem in balance, keep the overgrowth of certain species in check. The number of wild lions has gone down drastically across the globe, or with the only exception being Africa. Lions have naturally settled in India, leading to a steady increase in their population in the country, especially in Gir forest, which is the second largest home to big cats outside of Africa. Okay, as we can see, beside us we have it. You see here, Gir National Park and Wildlife Sanctuary. The number of them has increased at a steady rate. It's not decreased, increased. The population of lions rose from 523 to 674 between 2 years, 2015 to 2020. They are distantly related to African lions. Remember that. And they are bigger in size. African lions are bigger in size and they're distinctly related to African lions. As you can see, Congo, Nubian, West African, Southwest African lions, these are African lions. We have our cute Asiatic lion over here. Of course, in pictures they are cute. Wouldn't want to come in front of them. Then Transvaal lion is another lion. Okay. Now key facts include they are listed in the Schedule 1 of the Wildlife Protection Act, in the Appendix 1 of the sites, and endangered in the IUCN Red List. Erstwhile range of Asiatic lions in India was even up to West Bengal, East and Riva and Madhya Pradesh, Central India. Now we have seen their presence only in the Gir National Park, Gir Wildlife Sanctuary. Now, practice question for which you have to answer correctly. I will take your names in the upcoming segment. Excavation site, we have to relate them with the period they are excavated for. Tewar, Chalcolithic, Kiladi, Neolithic, Burzaho, Sangamera. So how many pairs given above is or are correct? Let me take the names of those students who have answered my last question correctly. Many of you have answered it correctly. If I don't say that I will take your names, you won't be able to comment or what? So, what was our question? Let me remember that first, because this was a pretty long segment, right, for us. But it was very important for us to know about these many things, so that you do not fall behind when it comes to the current affairs part. Pardon me. Yes. The correct answer would be option C. Okay. Option C will be correct. Riya, why have you answered it incorrectly? Tejas has also answered it incorrectly. Simran? No. Option C is correct. Arpit? Only Arpit has answered it correctly. What's wrong? So please make sure that you, from the next time onwards, you answer it correctly. All the 3 statements given here are correct. I have walked you through to it. Make sure you do not just see others' answers and then comment it. That won't help. Okay, that's it. Thank you so much for watching.